Let me provide a scenario to better explain the complicated workers' compensation process. The injured worker is a nurse that works at a hospital. On June 1st, 2013, she injures herself while lifting a patient. She feels immediate pain to her right shoulder and back. The first step is to report the injury to her employer. The employer has an insurance company that handles their workers' compensation. The insurance company has 90 days to decide whether they are going to accept that the injury happened at work, and also is going to decide which body parts they accept as being injured. Assuming all goes well, the insurance company is going to accept that the back and the right shoulder were injured at work. The nurse then has the right to seek medical treatment with a doctor within the employer's medical providers network. Continuing with the example, she goes to see Dr. Smith, who puts in a request for authorization for a right shoulder MRI, physical therapy, and anti-inflammatory medication. The employer's insurance company has the right to directly authorize the treatment, or they may decide to put the request in through the utilization review process. The utilization review will send a letter with a determination to the injured worker, his or her attorney if they are represented, as well as the doctor. What happens if utilization review authorizes the right shoulder MRI but denies physical therapy, for example? Recently enacted Senate Bill 863 has enacted a process to appeal utilization review denials. This process is called Independent Medical Review, or IMR for short. Along with the utilization review determination letter, an IMR application will be enclosed. The injured worker has 30 days to submit the IMR application to the state of California asking for an appeal of the physical therapy denial. Now keep in mind that utilization review and independent medical review are only relevant in situations where the injury is accepted as well as the certain body parts are accepted by the insurance company, and the only remaining dispute is the need for the medical treatment. If you have an attorney, we work together to gather the evidence necessary to prove that there was a work injury and that the body parts were involved. And we can go to trial at the Workers' Compensation Appeals Board to fight for it. It's also possible that we can agree upon an agreed medical examiner to do an evaluation and resolve the dispute. If you don't have an attorney, usually the only way to resolve a disputed injury is through the state of California's panel qualified medical examination process, wherein a randomly selected QME doctor will evaluate you and render a final determination. Senate Bill 863, enacted on January 1, 2013, drastically changed the process for an injured worker to obtain medical treatment through workers' compensation. The IMR process was created as part of this bill. When the employer's insurance company doesn't authorize the medical treatment requested, the employee has the right to appeal that decision with the state of California through the independent medical review process. When the employee receives a letter that the medical treatment is denied, he or she has a very strict 30-day time limit to submit an IMR application. There is no exception to this, regardless of whether you have an attorney or not. If the IMR application is not sent within 30 days, then for the most part, the treatment is going to remain denied for an entire year with limited exceptions. The insurance company's claims administrator is supposed to fill out the entire IMR application absent the signature. However, from our experience, there's a lot of erroneous and incomplete information on the application. There are also many other details and concerns that we as attorneys look into and pursue, such as whether the employer's medical treatment review process was timely and proper. We have the ability to go to the Workers' Compensation Appeals Board on certain grounds to fight the denied treatment if everything wasn't done correctly. There's a lot at stake for the injured worker, so it's best to be represented by an attorney. The application is initially reviewed by the Administrative Director, or AD, of the State of California's Department of Industrial Relations Division of Workers' Compensation. Once the AD determines that the application is eligible for IMR review, a letter will be sent to the injured worker and his or her attorney notifying them that it has been assigned to independent medical review. At this point, The IMR case is handled by Maximus, which is a private company contracted with the state of California to conduct these reviews. The first step in any workers' compensation claim is having your employer accept that there was an injury at work. Even if the insurance company accepts that there was an injury at work, they might not admit that certain body parts are involved. They might accept the right shoulder, but deny that the back was involved. The utilization review and IMR processes only apply to accepted injuries and body parts, and the only issue is the need for medical treatment. As attorneys, the first step is getting your claim admitted. There are various avenues to do this, whether it's gathering the necessary evidence to go to trial or agreeing upon an agreed medical examiner to decide such issues. Again, the process is very complicated, every step along the way, and it's important to have an attorney represent you.